I am so excited to be joined by Raluca Soica. Now, she is a lawyer. She is specifically dealing with estate law, and that's what we're going to be speaking about today. We're going to talk about what happens with real estate after death. It's not the most sexy topic, let's be honest, I get that, but it is one of the most critical and crucial topics we can discuss. There's so much gray area, and it's like this never really gets discussed until there's a tragic event. So let's share some information and let's talk about something that's not that comfortable to talk about, but absolutely critical to talk about and to get your ducks in a row regarding. So we're going to be talking about estate law and wills and just estates and things that you should be considering when planning your life. So with no further ado, kindly help me welcome Raluca. Thank you so much for joining us here, Raluca. Now I have to know, what do you do?
I'm a lawyer and I practice wills and estates and real estate law.
Okay, what does that mean? I know that you have like three different aspects to what you do. So can we break that down?
Absolutely. So, wills and estates, I break it down into the wills part. So and I call it the estate planning part because we do so much more than wills. There's a whole part to estate planning before the drafting of the will. That is basically you're setting the path to how the will be drafted and why, and there's a way and sense to things, to the way of, of drafting a will in a certain way. There's a lot of topics to be discussed with the clients in the estate planning process before the will is drafted. That includes more than just how you want to distribute your assets to what beneficiaries. We look at finances, we look at relationships, we look at blended families, we look at, does it make sense the way the executors that you're appointing, the attorneys in the power of attorney, just a very, very broad conversation, all encompassing that makes up the estate plan. And then we draft the will and then sign it.
Discussing wills. Is there anyone that shouldn't have a will? Like, who is a will meant for? What is a will? Let's start there. Raluca, what's a will?
A will is a document that comes into play when a person that passes away, and it is used to appoint an executor to execute to administer the person's estate, and then to distribute the assets to the beneficiaries that are named in the will. Generally, really high level, that's what a will does. Now, you can use one will, multiple will strategies for business owners. We can work through the will and the estate plan to reduce estate administration tax. There's a lot of things to talk about under the umbrella of a will, but high level, that's what a will is. And to add to it, I get this question a lot from my clients. What's the difference between a will and a power of attorney?
Mm.
And the difference is that a power of attorney is used when a person is very much alive, but they need help with financial or personal care decisions. You don't distribute any gifts in the power of attorney. You just name an executor who can make, an attorney, they're called attorney, pardon me, who can make decisions on your behalf. A will is once it comes into play once you pass away, and at that point the powers of attorney are worthless once you pass, because you're not alive anymore. So once you pass away, the will kicks in, and that's the document that, as we said, appoints an executor and distributes gifts to beneficiaries.
Now, who should have a will?
A person who's over 18 and who owns assets, which is, most of the Canadians. But I have done estate plans for people who just had one bank account. So let's make a distinction. What happens between a person who has a will and a person who doesn't?
That was my
Because
next question. Good.
that would kind of help answer this question. So if a person dies without a will, they're called intestate. That's the word. You die intestate. And then in this case, their estate is distributed in accordance with the Succession Law Reform Act. And by the way, I'm practicing in Ontario only. So this is only related to legal information related to Ontario only. So Succession Law Reform Act addresses how the assets would be distributed and to who, etc. Now, that's what the law says. In case of a person who dies intestate, somebody needs to step forward and assume the duties of executor. So assume the duties, apply for certificate of appointment, do this work, which sometimes is it feels like a job sometimes because it's a lot of work being an executor. So assume this job essentially of being an executor. In this case, it's people in your life dealing with the aftermath and trying to pick up the pieces. Versus if you have a will, you've already thought of somebody who would be a good person in your life, who's financially responsible, who you trust with your money, your children, etc. So you've already done the thinking. You've ideally had the conversation with that person. You've thought about guardianship for your minor children. You've thought about, so there's more than just how your assets are distributed upon your passing. And it's like all the thinking before, the naming in for registered assets like RSP, the thinking of naming a beneficiary or contingency beneficiaries for life insurance, all this thinking ahead of time to make life easier for those left behind. That's what an estate plan does essentially.
What is the biggest thing that isn't considered when drafting a will?
Yeah, so a lot of my clients are surprised about the in-depth process that we go through to prepare a will, because they think that they come in and I just ask them, tell me how you want your assets to be distributed. Like that's what they think a will drafting process is like. Versus they come in and I give them a questionnaire, and then we have a very in-depth meeting where we talk about everything they put on that questionnaire and essentially their life in a nutshell at that point in time. So they're surprised about the fact that having an estate plan done is not something simple. They come in thinking it's something very simple, and sometimes it is. I'm also really passionate about communicating with my clients and educating my clients. So I tell them a lot about how the courts look at things, about potential risks, I point out a lot of things that they didn't think about. A really popular one is clients are not aware they're aware that there's something called an estate administration tax, formerly known as a probate tax, but they don't really know that there's such a thing as a strategy and you can work to have that reduced on death, and what are the things that you can do. So that's a really big topic of conversation. Another big topic that clients are surprised about, sometimes there's some real estate properties that can skip probate. Literally, it usually applies to people that have owned their property since 2000 and earlier, and they bought it in registry system, and then the property got converted while they owned it. It got converted to land titles, and because it's this exception called first dealings, and because they fall within this very narrow exception, very few people fall within this, and there's certain other parameters that title needs to have. When I look at title and I deliver them the good news, and I've had the benefit of doing that to a couple of my clients in the past year, and I told them, you're going to save $20,000 in tax. Congratulations. And we planned for this on how to do this. They're like, oh my God, I've never heard of this in my entire life.
Can we also kind of touch on what is state administration tax?
Oh, yes. Estate administration tax is a tax that is applied on all the assets at the date of death. So when a person passes away, we make a list of all the assets at date of death. The certificate of appointment, what is it? It's because the will appoints an executor, so why do we need what is that? So it's the probate process. That's what it is. It's formerly known as probate. They changed the name now to the process called certificate of appointment. And it's the executor submitting an application to court where the court vets that this will is valid and that they are formally appointed as executor to this estate, and that they can, third party institutions such as the land titles office or banks, other financial institutions, they recognize this common document among any executor who wants to act, called the certificate of appointment. But they don't necessarily recognize a will. If the executor brings a will, they say, that's nice, but you need to go through the process. The court needs to put their stamp of approval on this will. And when we get from the court an issued certificate of appointment that you are indeed the executor stated in the will, then we'll go ahead and help you administer whatever we need to administer.
So essentially, is it a way to validate and confirm the validity of a will?
Yeah, among other things. But that's one of the things. But the most important thing it does is it recognizes that this is the executor that will administer this estate. So then institutions, they start opening the doors up. They start giving you access to bank accounts. You start being able to sell property. You can't sell property if you don't, a dead person can't sell property, and the executor can't sell the property without a certificate of appointment. So once you have the certificate of appointment, you can go ahead and sell the property on behalf of the estate. So all of these things, it's like you have your door opened. That's it. It's like an open door. Okay, let's go. You're ready. You're good.
The key to the city.
Yeah, that's it. That's it. You got it. Estate administration is the process of administering a person's estate after they passed away. When a person passes away, they have, even if they don't have a lot, even if I go back to my previous example where I had a client with just one bank account, even if there's one bank account, the bank probably will ask for certificate of appointment regardless. So that's why even if a person has a very simple estate, they should still have an estate plan done and have a will done, because then it's just easier on the people left behind to access that account. They can just, the process to apply for certificate of appointment is much easier with a will than without a will. And it's a lot cleaner because there was estate planning done.
Does everything go into the will? Things like pets?
Oh, that's a good question. No, not everything goes in the will. Pets are considered personal property in Ontario. I think some of the provinces, if I'm not mistaken, they changed them to sentient beings. So they changed their status from property to sentient beings. But Ontario still considers them personal property. So that means that you can't really leave money in a will to a pet. But you can do several things. You could do something called a pet trust, where you leave money to someone. You leave your pet as a property to someone, and then you leave money, cash, a legacy, that's what it's called, to that person to help them pay for the pet's expenses during their lifetime. And the other thing you could do is, so you could set the money up in a trust and have your executor oversee that, and it's very formal. It's also very expensive. Having a trust is not something simple or cheap. Or the other thing that one could do is literally gift the pet and gift the money to someone and have a private conversation telling them how they see their pet being taken care of after they're gone. I'm drafting that right now for some clients in a will. But if you have dual wills, which business owners have, is popular, or homeowners that I was just talking about earlier that fall within that exception, you put the house, what you do is you put the house in a secondary will then. So then if you have this dual will strategy, you can start moving some assets to a secondary will, And then while technically they're still part of your secondary estate, they don't fall within the estate that gets probated. So they skip this layer of estate administration tax that exists on an estate. So there's, yeah, we utilize this strategy quite a bit with clients.
Now, can we kind of do a hypothetical sort of setting? What would happen in a marriage and one person passes away, both people have wills? Do the wills always kind of talk to each other in the sense of they're comparable? And what if one will isn't comparable to the other, but the will for the person that's still alive, like when does his will or her will kick in? Do you know what I mean?
Yeah. So married couples often get wills done together at the same time drafted by the same lawyer. And they do that because 99.9% of the couples will gift everything to each other, and failing that to their children, or if they don't have children, maybe some nieces or nephews, etc. So it's very much, they're called mirror wills. They talk to each other in a mirror. They're identical. And when married couples get wills done together, they become joint clients of the same lawyer. So everything that's shared within that trinity, so you will, between the clients and the lawyer, there's no solicitor-client privilege between one of the clients and the lawyer. So anything is shared at face value between the three of them, openly and freely. And so that's a popular strategy. But there's also couples that one of the spouses chooses to have a will done on their own, which they can. It's not mandatory that they have their will done together. In that case, I would ask the spouse why their spouse is not coming. So why? And then I've had a case like this, and the reason was very simple: is that my spouse is just they're not very organized, and they don't like doing this stuff. And I try to get them to come, but I feel like I need a will, and if they're not getting their will done, I can't push them more than I've already had. So that's a very popular answer. And then in that case, then we just draft the will of the one spouse, and that's that.
Got it. With estate planning, does divorce ever affect an active will?
Yeah.
Okay.
Yes, it does. Ontario law for succession law is quite an old law. There's laws that haven't changed in a really long time, but there's been a lot of change since the pandemic, actually. One of the things that changed is how the law treats married versus separated spouses. So prior to the pandemic, prior to 2021, if a couple was married, so that's the key. Married couple and common law couples have different rights. Okay, so I'm just still, even to this day. So I'm just addressing married couples right now. So if there was a married couple prior to 2021, and let's say they had wills, and then they were separating, ready to get divorced. In this case, the separated spouse had the same rights as the married spouse. So even though one of the spouses would go and have a will redone to remove the old spouse from the will, to remove the ex from the will, unfortunately, the law gave rights to the separated spouse as if they were married, which meant a married spouse is allowed to void their spouse's will. They're allowed to say, I am not taking under my gift under this will. I do not agree to this will, and then the will gets voided. I'm serious. So instead, what they get to elect under equalization, which means as if they were divorced. There were situations that didn't make any sense where couples were separated. They were in the process of getting divorced, but didn't get there. One of the people would have done a will to eliminate the ex-spouse from the will, but because they're still married, let's say that person would pass away, their spouse would say, I don't like that will. I still want to get half of everything as if we were divorced, and that would void the will. So what the Succession Law Reform Act did, there's an adjustment to it to adjust for separated spouses now, but spouses have to and they're treated the same as if they were divorced. But in the case, there's certain rules, so they have to have this separated for at least 3 years, or they have to have a separation agreement in place, or a court order that deals with their affairs with respect to their separation. So there's conditions to it, but still, it's still better than before. So separated spouses, as long as there's something official saying that they're officially separated, they don't have the same rights as a married spouse. Thank God. On divorce, if the person doesn't change their will and then they get divorced, any gifts to their ex-spouse or any appointments in the will, such as executor appointments, are voided, as if the person predeceased them. So if I'm married and I get divorced and I have a will and I'm not changing my will, and then I pass away, anything I would have left to my spouse is void. It's as if he predeceased me.
So what if they are, and I want to make sure I get my terminology right, what if they are the executor? Then what happens?
Then they're not allowed to be an executor anymore. Their role, so they're removed as executor, even though the will says that they're an executor. Thus the role of executor goes to the alternate executor that's appointed in the will. This is a really good gem. A will can still be a good will, valid will, even if there's no valid executor in the will.
Okay.
So somebody needs to step up and apply to be an executor. They will apply under special circumstances, but the will is still very much valid. And they can still get a certificate of appointment. So even if the person just named the spouse in their will and no alternate, that's still okay. The spouse is removed and somebody needs to step up, or the alternate that's appointed in the will just become the executor. And then I do the third piece. I practice real estate. And the reason I started practicing real estate is because my estates had a lot of real estate needs. So as an estate planning lawyer, you need to understand real estate. Most of my clients have property, so they need to be advised, and it's their most expensive asset in their estate. So they need to understand how the property will pass, how title is held, what it means to them, etc., and if they're okay with it. And same with the state administration, people passing away with real estate, owning properties. So that property eventually needs to be transferred to a beneficiary or sold. So anyway, that's how I started practicing real estate, to be a better estate lawyer. And then I just expanded my practice to regular purchases, sales, finances, transfers of title.
I'm so happy to have a better scope of what you do. I have an incredibly important question.
Mm-hmm.
Can we talk about probate?
Yeah.
When a family member passes away, I have a lot of my clients come to me and they're like, okay, devastating time. Family member passed away.
Yeah.
We have to sell the property.
Yeah.
Let's get it on the market.
No.
And for me, exactly. For me, I'm like, ooh, no. There is quite the degree of work to happen before that kicks in.
Yes.
So let's say they come to me, I say, ooh, actually, there's a lot to do. Speak to my lawyer, Raluca. I'm going to send them to you. What happens?
Okay, so first off, unless the person owned property in first dealings, which is the exception I mentioned earlier, where they own property in registry and then it got converted to land titles, and then there's a specific estate planning strategy in place for this. Unless that's the case, most properties need to go through need the certificate of appointment in order to be sold. So an executor cannot sell property because it's still in the deceased name, and the deceased cannot sell property. So you need to have a bridge somewhere. So, and that bridge is called probate. So with probate is essentially applying for certificate of appointment of estate trustee, naming the executor as the official person appointed by the court and by the deceased to administer this estate. And there's a whole process. There's it takes a little bit of time to pull the information together, submit the application to court, submit payment for the estate administration, and then we wait. And then unfortunately, that's why I said earlier, when you say that, you know, the executor wants to sell the property, it's a no, because you need to have the certificate of appointment from the court before you can sell this property. So we wait. We don't know, once we submit the application, we don't know how long the court will take. Toronto Superior Court is very busy. It's probably one of the busiest. One is actually probably the busiest court in the whole of Ontario, and it's very unpredictable how long it will take to get the certificate from them. There was a point in time when it would take longer than a year, and of course, values for real estate would change drastically within that year. The whole market could change, you know. So that's why we want to have the certificate of appointment first before we list the property. But I also understand that sellers want to take advantage of a certain market, or it's summer and properties sell better, they're going to have more views, etc. So you can still list it, and you can still receive offers as long as there's a condition in the agreement of purchase and sale that says that the sale is conditional on receiving the certificate of appointment, and without any other sort of conditions, like we have to receive the certificate by so and so date, because it's something that's out of anybody's control. It's just in the hands of the court, and that's that. So there's certain clauses certain wording I like to see in these clauses in the agreement of purchase and sale that doesn't bind the seller into something that they can't offer, you know, like promising something that they can't deliver on, because that leads to a default, and they can't sell the property even though they want to, and then they're going to default under the agreement of purchase and sale, and which estate wants a lawsuit on top of everything? Right? That's why it's either you either sell the property with this condition, but then there may be more negotiation on price, because you don't know when the closing date will be. Is it 3 months from now? Is it 6 months from now? We don't know. Or you just wait, you get the certificate, and then you can commit to a date, a closing date, no problem.
Do you think it's possible to do a deep dive in what the probate process looks like? Or is that like a silly question?
No, it's not a silly question. So this is what I do. I'll tell you what I do with my clients. So people understand what exactly is this mystery of probate. So clients come to my office, they tell me a person passed away, so-and-so institution is asking for probate, or they need to sell the property and they were told they need to get probate. So what we do is this. We first gather all the assets of the estate. I need to know all the assets at the date of death that the deceased owned. I ask for the original will, original death certificate, and I start the process of putting together the forms that fill in the application for certificate of appointment. So, and it asks all kinds of information. So I usually give a questionnaire to my clients to fill out, which gives me all the information that I then input into those forms. And it's all kinds of information about the deceased, about the people, the executors that are applying, about who the beneficiaries are, if there's any minor beneficiaries, incapable beneficiaries, etc. So all of this information that I get from my clients, I gather it all together and I input it into this one application. Then I tell my clients that they need to prepare a check for the estate administration tax. I can't calculate how much it is, and I tell them to bring a check. They can usually get a check from the deceased bank account. The bank will help you prepare that, and I can guide them on how to ask the bank for that. And so once we have the check and we have the application, there's a couple more documents I need to prepare on my own. I put it all together. We sign, the executor signs, we submit it to court. That's the process of probate, of applying for probate. And then once we submitted it to court, then the court takes their time, reviews all the documents, and gives me a certificate of appointment. And right now, certificates of appointment can actually be issued through email. So the original is actually issued in a virtual copy, and it's signed electronically. So it's an electronic certificate, and it cuts the time of mailing. So the court doesn't mail me the certificate anymore. They email it to me, so it cuts that 2-3 weeks of transit, which is great.